Okay, let's now revise the chapter of prevention of oppression and mismanagement. A very small chapter, chapter 16 of Companies Act 2013, starting from section number 241, going till section number 246, right? So, ideally, we have roughly only 5 sections to read. The sixth one is not exactly a full fledged section or anything like that. So, when we begin and when we talk about the terms oppression and mismanagement, they have to be understood, right? Okay. But before we actually go to understand the terms of oppression and mismanagement, one very important thing that has to be known and that has to be understood is the majority rule. What is majority rule? See, majority rule is something that prevails not just in companies but everywhere. If there is a room of 10 people and you need to come to a decision, it cannot be all 10 people agreeing on the same thing. Someone might disagree. But does that mean that we can't proceed with that decision? We can. Because majority agrees. So it is quite obvious that when you want to run a company, you have to take a number of decisions, and all the decision making takes place through majority only, right? So anyone who has the major number of shares has the control of company, right? He has the control of the company, and that is basically the principle of democracy that has been here since ages, and it was basically established in the case of Force versus Harbottle. So we have a case law wherein some people, there are two shareholders basically who alleged that these directors of the company have misapplied certain company's property. The court rejected their plea on two grounds. Ground number one, that they have misapplied company's property and not yours. Company is a separate legal entity, it is not you. So you are separate from company and you can't initiate that legal action because harm has been done to the company. Point number one. Point number two, the decision was lawfully taken by majority, and every now and then company takes n number of decisions on the basis of majority rule only. So every now and then if I have a problem, oh my god, company has entered into this particular contract, no I disagree, company did not declare dividend, no I disagree. So every now and then if people disagree and they move to the court, there would be endless litigations and no problem solving. So that is why court clearly established in this case that court is not going to interfere in the internal management and it is going to be run according to majority rule only. But then there comes certain problem because people at times could abuse this majority rule. Like what, ma'am? Like maybe the ones who have majority shares are making and taking all the decisions in their own favor and somehow harming the people who have lesser number of shares. Maybe, right? Like, for example, the majority shareholders, the ones who have majority shareholders, they have appointed themselves as directors. Can they? Yes, because the power to pass OR, SR, everything is with them only. So they appointed themselves as director or their own choices as directors and also approved that remuneration and everything, right? So they're getting very heavy remuneration. The company is earning profits and it's being paid to the directors in the form of remuneration. The minority shareholders are just sitting and idly watching because they're not even being getting any dividend or anything like that. Company doesn't want to declare dividend. It's routing the traffic through remuneration and taking it. And this has been happening for years and years and years. Now, what do these minority shareholders can do? Do you think it is fair to them? No. That's what oppression is called. So basically, when the general rule is that majority rules, but even the minority or even the minority shareholders can take certain actions to stop this. Maybe that's not fair, right? Certain actions under common law and then certain actions under Companies Act. So under Companies Act, we have different thing and this is something different. So first thing that you have to remember is what is majority rule, and then secondly, actions which may be taken by shareholders in common law, or you can also call this as exceptions to the majority rule. If the company is entering into any act which is ultra wires, then one shareholder can also go to the court and obtain a stay order that this company cannot enter into something which is ultra vires. If there is any fraud which is done by on minority, if the wrongdoers in management actually control the company, wrongdoers in management, that means the directors who are managing the company are managing it um, in a rubbish manner, right? They can be removed by the shareholders, but they are the only ones who are controlling the company also, because they have majority of the shareholders. So we can't even remove them, right? So how will we take action and how will we reach the court? Because they will not allow us to sue them on behalf of the company, because they are in control of the company also. Next is, sometimes act requires some special resolution, and that act has been passed, that the provision, that resolution has been passed just by simple majority. So is it correct? No, it's not correct. So in such a situation, an individual shareholder, you have the right to go to the court and stop the company, restrain the company from doing so. Personal actions by shareholders. Shareholders undoubtedly are conferred with many rights, like right to dividend, right to vote, etc., etc. So if they are deprived of any right, unnecessarily they're not getting the right to vote. So if you're doing so, we can approach to the court. Breach of duty, right? Minority shareholder, you can bring action against the company where there is breach of duty by the director. So these are the general remedies which are available under common law. Now, we also have Companies Act, wherein certain minority shareholders get a lot of rights. We have read it over different sections, right? Like if we talk about appointment of directors, we have read about SST. SST is what? Somebody who is not owning a lot of small shareholders, right? They have a right to elect one of their directors. Correct? Okay, we also have read something about e-voting. E-voting is what? Even if I'm not able to participate in the decision making every time, why? Because I'm not able to walk to the meetings, I'm not able to devote that much time, effort, energy needed. So I have this remote e-voting facility also, where I can every time register my vote. Correct? We have section 188, where if the company is entering into a related party transactions, then that has to be approved by the members, and the related members cannot vote. So it's ultimately us who are not related, who are kind of minority, they are approving their transactions. Correct? We have a beautiful chapter 16, prevention of oppression and mismanagement, right? We also have the previous chapter that we read, reconstruction and amalgamation and compromises. So we have section 235 and 236, where minority shareholders get certain rights to apply to NCLT when their shares are being acquired, right? So in that cases, so all these provisions are available under Companies Act. Okay. Oppression, my dear, you have to remember four basic things about oppression. Wherever any case study is being asked as to decide whether this is a case of oppression or not, you need to judge it on four basic parameters: visible departure from fair dealing, capacity as a member, continuous process, harsh, burdensome, wrongful. Okay. So, any act, or if the affairs of the company are being conducted in a manner which is prejudicial to the company, or prejudicial to public interest, or prejudicial to members, then that's actually oppression. But it should be in the capacity as member, it should be a continuous process, it should be harsh, wrongful. Got it? Okay. So, now we have these sections. Anyone who is eligible under Section 244 can make an application under Section 241. Tribunal passes an order or many orders under Section 242, and thereafter we have the post effects under Section 243. Okay, we also have an aloof section, Section 245, which talks about the class actions, right? Okay, so let's now begin with Section 241. But to start with Section 241, we actually need to know who are the eligible members under Section 244 who can make an application. Cut to, let me tell you one thing very straight. Although majority rule is there, but if, now forget what minority shareholders can do under common law. Forget it. What you can do under other sections of Companies Act, that also forget. Now we're starting with chapter 16, right? So we are only going to talk about this particular chapter and what actions you can take in this chapter. So if you are a minority shareholder, right, and something continuous harsh acts have been happening to you, right, in the capacity of member you are suffering, then you can apply to NCLT for seeking relief from oppression and mismanagement, and NCLT can pass various orders. But can one member go and raise that complaint? The answer is a big no. You have to be those eligible members. Who are eligible members? Come on, let's see that. So who are eligible members? We come over here. Members, if the company is with share capital, then 100 members or 1/10 of total members, right? Okay. That is one criteria. That is one criteria on terms of on the basis of number, lower of these two, or in terms of value, the members who are holding at least 1/10 of issued share capital. Please be very careful while you are writing answers for this particular section, because this is a very commonly asked question. And here we don't write paid up capital, it's issued share capital. Okay, it's issued share capital. If the company is without share capital, 1/5 of the total number of members. So this is the requirement. Now let's say, ma'am, 99% of the shareholders or 99 shares are being held by that majority group and I have just one share, I'm just one shareholder, right? So don't I get any chance to make an application? Well, if oppression is happening, well, NCLT may permit lesser number of members also. If you make an application to them, they can waive this requirement. Okay, so that is also an option available. Now, if you are making this application, you should have paid all your calls. If you are not paid your calls, then you're not eligible to make an application. So these members are eligible to make an application to NCLT. Likewise, CG is also eligible to make an application to NCLT for seeking relief from oppression or mismanagement. Okay, now let's say there is minimum requirement of 100 members or 1/10 of total number of members. Let's say in a company there are 800 members, so 1/10 comes out to be 80 or 100, whichever is lower. So 80 become eligible. Now 80 members have actually filed the application, but later on 5 members withdraw it. So 75 left. Is it valid and still maintainable? The answer is yes, because you need this requirement only at the time of filing of application and not later on. Not later on. Okay? Okay. So now we come back. Now, eligible members who are eligible to make an application, that we have already got to know. Now, any member, if you are eligible and you complain two things. You complain of oppression or you complain likelihood. Oppression means what? If the affairs of company are being conducted in a prejudicial manner to public interest, prejudicial to members, prejudicial to interest of company. So this is called as oppression, which I have explained you like in absolute detailed manner in the class, right? And then second is the likelihood. Likelihood means what? Maybe overnight this entire Ambani shares have been sold to another group. So there is going to be a change in the majority shareholders. Yesterday the control was with this particular group, now the control is with this particular group. Fine, that is absolutely normal. There could be a change in directors, there could be a change in shareholders. What is the problem? The problem is that it is not in the best interest of creditors, shareholders or debenture holders, and there's likelihood, there are very high chances that affairs will now be conducted in a manner which is prejudicial, which may be harmful to public interest, which may be harmful to the members or any class of members, you can say. Fine. So these are the two cases. If there is any member who meets the eligibility criteria as mentioned under section 244 has this complaint, they can make an application to NCLT. Now NCLT, an application is being made to you, right? An application is being made to you. Now you are of the opinion that yes, the affairs, there's a problem. And winding up would be unfair. Winding up would be unfair. Winding up is just, but it would be unfair. That in normal situations, I would have wound up the company. But because if I wind up the company, it would not be fair for the members, right? For the shareholders, for other people, right? So I cannot do winding up. I will pass other orders to revive the company, okay, to better the company, right? So tribunal may pass orders as it deems fit. Whenever tribunal passes the order, within 30 days, the order has to be filed with ROC, and thereafter we have the consequences as given under section 243. Now the question is, what orders can be passed by NCLT? What orders can be passed by NCLT? That, of course, we get in section 242. So section 241 tells us who can, section 244 tells us who can apply, section 241 tells us when can you apply, right? And section 242 tells us what are the powers of tribunal, section 243 what are the consequences. Now section 241 has yet another aspect to it. What is it? In fact, I wouldn't say just section 241, but it is a whole chain of section 241 followed by the order under section 242 and followed by the consequences given under section 243. So what another thing can be done is the CG's power to request inquiry to NCLT into fit and proper person. So if CG feels that any person is engaged in fraud negligence, or maybe the company is conducting the business, the person is conducting the business not with the sound business principles, or maybe it is being conducted in such a manner that it could cause serious injury to trade, industry, right? Or it is conducted with an intention to defraud the creditor. So whoever is the person involved, it could be the director, etc., right? MD, whatever it is. Now, CG feels that whether this particular person is fit and proper or not to be as a director. So, CG in that case will initiate a case and request NCLT to inquire into the same, right? Okay. Now, NCLT, along with the concise statement CG gives that, now NCLT will pass an order whether he is fit and proper or not under section 242. And if he is not fit, then he will be removed. He will be disqualified for 5 years. He cannot be connected with the conduct or management of the affairs of any company for 5 years, and he will not be entitled to any compensation. That is the consequence that we get under section 243. Okay, I hope that's clear. Now we come to section 242, that is passing of orders. So tribunal has received an application under section 241. Now tribunal feels that yes, the company's affairs are prejudicial and winding up would be fine, would be just, but to wind up the company, it would unfairly prejudice the members. So NCLT will pass other orders apart from winding up, right? What orders can it pass? First is regulation of conduct of affairs of the company in future. Whatever you have done or you have done now, in future you have to do it this way. Maybe you have to hold these many board meetings or something like that, right? Then there is a deadlock between the members and these are oppressed, these are doing this. So you buy the shares. Either the shares will be bought by these persons or by the company that may be ordered, right? Now, if the shares are being bought by the company, that means it is buyback of shares, which has to be followed by consequent reduction of capital. So accordingly, that can also be done. Then maybe you are transferring or you're allotting the shares to your one majority group only. So restrict allotment. Or maybe transferring, buying shares from some people and increasing your stake. No, restrict transfer. So that order can also be passed. Then termination or setting aside or modifying your agreement, that is company's agreement with the director or with MD or manager, right? Okay. Termination, setting aside or modification of company's agreement with any third person after giving him a notice and his consent, then that can also be done, right? Now supposedly you have an agreement with your managing director that we will pay you a salary of 5 lakh, and based on the circumstances you feel they are unnecessarily drawing very high salary, not doing actually any work, so you have modified the agreement and made it 1 lakh. Right now that particular person is suddenly demanding that these damages have to be paid to me. So it has been clearly stated in section 243 in the consequence that if NCLT terminates or sets aside or modifies any agreement, then you will not be entitled to any claim or damages or compensation for loss of office. In fact, if your agreement is terminated, then for 5 years you cannot be appointed in the company as MD or manager or director in the company, right, without NCLT's permission. Okay, so that is the consequence that we see. Fine. Okay. Now, there is something called as fraudulent preference. Fraudulent preference means preference given to the creditor with an intent of fraud. Like maybe the company, you know that the company will be wound up in a couple of months. So you have already paid to a specific creditor who you know, right? So that is giving fraudulent preference, and that often it is reversed when we go through that IBC, right? So if there has been any transfer of money or maybe delivery of goods or any payment, transfer of property, anything like that within 3 months before this application, right? Which, if this was an insolvency case, would be deemed as fraudulent preference, then that same transaction can be set aside by NCLT here also. NCLT can also remove managing director, it can remove the manager or directors of the company. Once it has removed, maybe it can direct the manner in which they will be appointed, and it can also appoint its own directors who will be reporting to NCLT, right? So this can happen, this can happen. Then we have imposition of cost also, and other matters as may be specified. So these are many orders which may be passed by NCLT. Once NCLT passes the order, it has to be filed with ROC within 30 days, and that is it, I think so. There's penalty. Right, now we have consequences, which I have already told you, that you'll not be entitled to compensation, disqualified for 5 years from appointment, right? In both the cases, the consequence of fit and proper person also, and this way also, right? This is something that we have already discussed. Now, okay. Yes, here this is also something that I have already discussed. In opinion of CG, any person who is guilty, CG may initiate a case against him, application to tribunal to inquire into fit and proper person. So we have discussed this. And now we have something called as class action application. Class action application. Who are the eligible members who can make this application? If the company is with share capital, then 100 members or 5% of number of members on the basis of members, or if you are holding share capital, issued share capital. If it is a listed company, 2% of paid up share of issued share capital, unlisted company 5% of share capital. That means if I am a member and I want to make a class action application, so I have to accumulate either 5% of number of members or 100 if I talk about a number, or maybe if I am holding 0.5% of issued share capital, I accumulate like 50 other people, and together our shareholding is 2.5%. So are we eligible? Yes, we are eligible. If we are depositors, see, depositors can't make an application under section 241, right? But depositors can make a class action application under section 245. In the class, I have clearly stated you the difference between section 241 and 245. So please don't be confused and keep in mind the points so that you can actually relate which section the question relates to, right? So, okay. So eligible depositors, 100 depositors or 5% of depositors in number, and if I take on the basis of value, depositor who owes 5% of total deposit. So you fulfill or you meet any of the criteria, you can make an application. So eligible members or depositors, you make an application to tribunal, right? Tribunal will consider certain factors and may admit your application or may reject it. Once it is admitted, they ask you to give public notice in the newspaper, website, everywhere, to all the members and depositors, and there will be one single application only. All the running applications will be consolidated into one. No two class applications are allowed, and the application will be with the lead applicant. If you're able to decide who the lead applicant is, great. If you're not able to decide, then NCLT will decide for you, and NCLT's order is going to be binding on everyone. Now, what orders NCLT can pass and what are the factors which they consider before passing, before admitting the application? The members should, a member or depositor should have submitted the application in good faith. Is there any evidence that other than director somebody may be involved? Then is this application your personal one? Like, mean you can pursue this case in your own right, or it is a collective harm, right? Any evidence that or not exactly any evidence, Of course, it is with evidence only. What are the views of the members or depositors who are not interested in the application? Like in general, we want to know the view. If there is a classroom and there are 1,000 students, there are 300 students who had a fight, right? So they're asking for a remedy to me, right? But there are those 700 students who are actually sitting in the class. So I wanted to ask, what is your opinion? What actually happened? They said, yes, some wrong was done to them. So now their case is more strong. So I got to know the views of independent people also, right? Then what is the likelihood that your action can be ratified, right? So I have explained you these points in the revision class. It's not possible to like give you an example and explain you it in detail, right? So these are the factors which may be considered, and then you get certain remedies. Remedies like what? If you go to NCLT, NCLT can stop the company from doing something ultra wise, that is restrain from ultra wise, restrain also from committing breach of AOA or MOA. Then maybe you have passed a resolution and altered your articles or memorandum, but you have given wrong information to the shareholders, and thus they have passed the resolution for alteration, right? Now NCLT will declare that this particular alteration is void. Okay. Or NCLT will also say that you can't work and you can't act on this particular resolution because this resolution is void, right? Okay. Also stop the company from doing any unlawful activity, stop the company from doing something which they're not permitted to because the resolution has been passed by the members. Also help in claiming damages or compensation from the company, from the directors, from the auditor, from expert, from consultant, if they are involved in any fraudulent conduct, unlawful conduct, or they have given any misleading statement, right? And other remedies as may be obtained. Okay. Fine. Okay. This section is undoubtedly not applicable to a banking company. Fine. Okay.